Hello, everyone. Jared has asked, well, let me pay him a compliment first, if I may. Thank you, Jared, for your kind words. I probably shouldn't say this, my wife will get cross, but I've taught about 10,000 students in 7 different countries in 10 universities. I think, with all honesty, Jared was probably the single most memorable student I ever had. And not only because he's buying me a beer tonight. I thought of that before he said he was going to buy me a beer. Now, when he asked me to talk, he asked me to talk about something which is surprisingly complicated, actually. I don't mind that. I love the law of treaties in a way that I'll explain in a second. But it's about reservations to treaties and interpreting treaties, interpreting words. And I was happy with that until he told me only 10 days ago that 60% of you are not lawyers. So I had to do a rethink of the way I wanted to present the information. So I've ended up doing 2 presentations, 2 submissions. One, you will find in your pack or on the internet, a discursive analysis, somewhat for lawyers, about what I'm talking about. But I'll also now give you a PowerPoint that's meant to make these ideas meaningful to non-lawyers. So that's the goal, to make it meaningful to non-lawyers. But as I thought about this, after Jared told me what he wanted me to do, I couldn't help but remember one of my favorite cartoons. Can you hear me on this mic? Yes? It's this one. You can see there is a lawyer, well, there's a bridegroom who's a lawyer and a bride. Go to this one, Jared? Oh, well, I'll have to read it from the screen with my back to you then. There's a lawyer getting married and someone doing the service, and the lawyer says, for better or worse, the latter being defined as, but not limited to, the following subset of possible events not covered in Clause 23B. Whereas, and the caption is, why no one goes to a lawyer's wedding. The reason this came to mind was when Jared told me that I'm talking about something quite intricate, legally intricate, but to non-lawyers, I became filled with angst. And being filled with angst, I remembered this cartoon, one of my favorites. So, having said that, I can now turn to the formal presentation. Let me get that up for you. Thanks. Is this you? There we go. Good. And we want to get, there we are. Yep. Thank you. Yep. And it's this one, isn't it? The way I conceived of the talk was to talk about making international promises. I don't even want to talk about law quite, or indeed obligations. I almost don't like the word obligations. But I do like the word promises. When I taught international law for almost 4 decades, one of my favorite areas was the law of treaties. And I think 3 decades had passed before I discovered my students didn't like it so much. Well, I'm a slow learner, maybe. I don't know. The same was true of the law of contract. I love the law of contract. I didn't know students didn't like it. The reason is that I'm fascinated by promises, because much of the important elements of life relate to promises. For example, a promise to marry, buying a house, even for that matter, taking a flight. Aer Lingus or someone will make a series of promises to you, and indeed you to them. So I'm fascinated by this idea of promise. Hence, I've conceived of this particular presentation in terms of promises. And I divide it more or less into 2. The first is making international promises, and I want to talk about the issue of good faith. Then the issue of credibility. How will they believe our promises? And then I want to talk about something that Jared mentioned this morning and other speakers have mentioned, and that is immediate obligations and progressive obligations, or if you like, immediate promises and progressive promises. That's more or less warming up to my theme. Then I finally want to talk about what Jared asked me to talk about, which is reservations to a treaty. And I haven't read there, I didn't make that promise, or if you like, our government didn't make that promise. And then secondly, interpreting the meaning of the promise. What exactly does our promise mean? As to making international promises, insofar as many of you are not lawyers, it may be appropriate to say that in the modern time, the international treaty is really the kind of workhorse of the international system. Historically, it had been practice building up over some generations, but it no longer is. So that these days, when states want to conclude some important promises, they stereotypically do it by way of treaty. For example, dealing with terrorism, climate change, corruption, and so on. Turning then to the issue of good faith. Basic to all of this, which is dealt with by all of these issues, which are dealt with by the making of solemn international promises, is the belief that there's a high chance that the promises will be kept. Indeed, even in the bosom of the family, between parent and child, husband and wife, we tend to get angry if a promise is not kept. Well, a treaty is to be performed in good faith. I think someone mentioned that this morning. This is, in fact, the most fundamental rule of international law, and indeed, it's the most fundamental rule or principle, if you like, of international relations. A solemn promise we make will be kept. It's impossible to overemphasize the importance of that. So that even if we consider sensitive treaties like security ones, I have here the Egyptian-Israeli Treaty of Peace, or arms limitation treaties concluded between the US and Russia. Those treaties would only be concluded if we think the other side will keep its promise. Failing that, concluding such a treaty would not only be pointless, but absolutely dangerous. It would be foolhardy in the extreme to conclude some kind of defensive arrangement, arms limitation arrangement between, for instance, the West and Russia, unless we thought there's a reasonable chance the Russians would keep their promise, and they think the same about ours. This same belief that countries will honor their promises underlines all treaties, whether about controlling terrorism, or money laundering, or dealing with climate change, or the thing that concerns you this week, the rights of disabled persons. There is a belief when a state ratifies the treaty, it will try and implement that treaty in good faith. I turn now to the issue of credibility. Further underpinning the importance of the likelihood that states will keep their promises is the issue of credibility. I want to give you a couple of examples of that. The first one I've always thought was interesting, I suppose because I read it in the New York Times, or maybe it might have been the London Times or the Guardian, the day after Kissinger said it. It concerns Kissinger's interpretation of why the United States had to continue fighting the Vietnam War. The war lasted roughly 20 years, and when Richard Nixon won the election in 1968, some couple of weeks after that, Kissinger published a piece in the famous journal Foreign Affairs. And what he said was, the United States and its allies would continue fighting the Vietnam War, even though they had concluded the war could not be won by the United States and allies. Tragically, at least 3 more million people lost their lives. But Kissinger's explanation was this. He said the US would continue fighting because of the need to preserve credibility. And his language was so interesting that I've never forgotten it, and that was 40-odd years ago, was it? 50 years virtually? What he said was this: the commitment of 500,000 Americans has settled the issue of the importance of Vietnam. What is involved now is confidence in American promises. And he went on, however fashionable it is to ridicule the terms credibility or prestige, they're not empty phrases. Other nations gear their actions to ours only if they can count on our steadiness. In many parts of the world, the Middle East, Europe, Latin America, stability depends on confidence in, well, he put it, American promises. I'd be inclined to say stability depends on confidence in promises. I found that very poignant, because what he was saying is we've analyzed the fact we can't win this conflict, but we're going to keep at it because people have got to believe American promises. Given that 3 more million people died, I thought it was an unusual exercise in promise keeping. The second one is a little related. It's the issue of the anxiety of Eastern Europeans to get within the NATO umbrella when the Cold War collapsed. Virtually all the former communist countries wanted to join NATO. And all of them have, minus Russia and Serbia. The fundamental reason was to benefit from NATO's promise of self-defense in collective self-defense in Article 5. Let me just look at the important phrase for you. The parties agree that an armed attack against one or more of them shall be considered an attack against them all. I, as a young fellow, was taught to hide under a desk in case there was a nuclear attack, and I found it quite amazing that a couple of decades later, the Eastern Europeans that I was taught wanted to have a go at us all wanted to join NATO. And of course, they weren't necessarily wrong, because they felt that NATO would be the greatest guarantee of their security. This also is a matter of irony, because de Gaulle had said at some stage, the Americans won't keep that promise. Not that they're liars, he said, it's that they're naive. They don't realize that when it comes to the crunch, they will not go to the defense of some country in Europe and risk American lives. They're naive, unlike us Western Europeans, such as himself. The Americans said, de Gaulle is quite wrong. If there were truly an attack in Western Europe, and they had in mind probably Germany, it would constitute an attack on Western values of such a kind that the United States would have to respond. And to show their seriousness of purpose, they stationed 300,000 troops in Germany as a kind of hostage to the American promise. If the Russians act, we have to react. We have 300,000 troops there. Well, once again, we're dealing with the seriousness, the solemnity, the credibility of a promise. But now I want to get closer to what you and I are talking about this afternoon. That's other kinds of promises. It's fair to say that with regard to the conclusion of a human rights treaty, for instance, the civil and political rights treaty, the economic and social treaty, the disability treaty, states in principle intend to keep their promises. And in fact, nothing raises the diplomatic temperature so quickly at the UN or elsewhere than an allegation that a state is breaking an international promise. And in fact, to underline this, many of the treaty mechanisms, many of the treaty systems, the treaties, have a monitoring mechanism. That's already been mentioned to you once or twice this morning. The monitoring mechanism is meant to be an assurance that the state is really keeping its promises. So that if you look at some of the most important international treaties, they have a monitoring mechanism. For example, the famous Covenant on Civil and Political Rights, the Torture Convention, the Disability Convention, the comparatively recent OECD Convention about bribery, has one of the most sophisticated monitoring systems, one of the most careful monitoring systems that's ever been devised outside of arms control. The name of the game is to assure the partners we are keeping our promises. I now want, thirdly, to talk about immediate obligations and progressive obligations, or if you like, immediate promises and progressive ones. The obligations in most treaties are to be effective immediately when the treaty enters into force. For example, most of you are from Europe. The European Convention on Human Rights immediately guarantees the rights. So the treaty reads, the high contracting parties shall secure the rights and freedoms defined in Section 1. Shall secure. It's immediate. But sometimes a human rights treaty deals with things in a progressive way over the course of time. So there is no immediate guarantee of the right. An easy example is the other covenant, the economic, social, and cultural one, which reads, each state party undertakes to take steps to the maximum of its available resources with a view to achieving progressively the full realization of the rights by all appropriate means. Well, you can notice the progressive elements in that. To take steps, there's no guarantee now. To take steps to the maximum available resources with a view to achieving progressively by all appropriate means. This is a guarantee in good faith to go about securing the right over the course of time, but there is no immediate guarantee, unlike most human rights treaties. States ratifying the Disability Convention make both types of promise. You have been told that this morning, I think. On the one hand, certain rights are guaranteed immediately. For example, the right to liberty. But states also promise that economic, social, and cultural rights will be secured only progressively over the course of time. Well, now, having warmed up the theme of making promises and why promises are taken so seriously by states and the ways in which they underline the seriousness of their purpose and their sincerity, I now want to turn to the more difficult bits of international treaty law. I guess the first thing to say is that every developed society has a system for dealing with the making, the interpretation, the validity, and the termination of binding promises. That is to say, a law of contract. The international analog of this is the law of treaties. When states make promises, whether about disability or climate change or terrorism, there is a corpus of law to which they turn to see what their promises represent. Well, the first thing is the claim, I didn't make that promise. That is to say, the issue of reservations to a treaty. I did not make that promise. When a state ratifies a treaty, it may nonetheless take the view that it cannot accept a particular provision, maybe for constitutional reasons or for legal reasons or political reasons. And under those circumstances, it may make what's called a reservation. That is to say, it says to the depository, we cannot accept this particular promise. Well, the first question that may come to mind is, well, why allow such a practice? The view is taken that it's probably preferable that a state which can't accept a particular promise nonetheless participate in the enterprise of promise-making rather than be excluded altogether. I give you a simple example here. Let's say there's a treaty with 4 promises, 1, 2, 3, and 4. Well, the state may accept the first one and the second one and the fourth one, but for political or constitutional reasons feels it cannot accept promise number 3. So it would say to the depository, we do not accept that promise, or if you like, that obligation. Now, there's nothing wrong or sinister about that, although it might seem, perhaps to non-lawyers, a little strange. In one of the better of the books on the modern law of treaties by a British academic, he makes the comment, there's nothing inherently wicked or even undesirable in formulating a reservation to a treaty. It may be to adjust the state's obligations to conform to its own domestic law. This is especially true of federal states like the United States or Canada, Australia, Switzerland, and so on, where sometimes a sub-unit of the federal government has authority for a certain type of issue and not the federal government itself. Let me just double check something there. Oh yeah. Article 19 of the Vienna Convention on the Law of Treaties provides that a state can formulate a reservation except in 3 circumstances. First of all, if the reservation is prohibited by the treaty. Sometimes a treaty will indicate that no reservations whatsoever are possible, like the Law of the Sea Convention of 20 years ago provides that no reservations are possible. Sometimes a treaty may say that only specified reservations can be made. One of the most unusual ones is the second protocol to the International Covenant on Civil and Political Rights. The point of that protocol is to prohibit the death penalty, as has been done, I think, now in virtually every European country. It's dealt with in Article 1. So, arguably, to make a reservation on that, saying we will execute people under certain circumstances, is a kind of nonsense. But nonetheless, Article 2 goes on to say, a state can make a reservation in order to allow for capital punishment in the case of serious military offenses in wartime. So that while the protocol is meant to eliminate capital punishment, the second article says, well, you can do it in the case of serious offenses in wartime. And then maybe the most interesting one. A state cannot make a reservation if it is incompatible with the object and purpose of the treaty. That's a kind of reservation which it would seem would frustrate the very purpose of the treaty itself. An example might be where a state ratifies a treaty dealing with non-discrimination in public life, but says that certain forms of discriminatory treatment are okay. It would seem to be a kind of nonsense, frustrating the very purpose of the treaty. Now, it becomes sort of more fun, I suppose, but states can sometimes may object to what they regard as an impermissible reservation. Under those circumstances, the contracting party chooses to lodge what's called an objection, and it means that the objecting state does not accept the reservation in question. Now, this is probably beginning to sound like Greek to you, but I'm going to give you an example. It's not regarded as a hostile act to lodge an objection, but the objection might signal to the reserving state that something's wrong with that reservation. A good example, I don't know if I have it here. Let me just look. I don't. When Chile ratified the Torture Convention provides that there can be no reason for torture whatsoever. No exceptions. But when Chile ratified, she said that torture would be acceptable if done under superior orders. In other words, if your commander ordered you to torture. Well, that's a kind of nonsense. So that a number of European states objected and said that reservation is ridiculous. And after a couple of years, Chile changed her mind and withdrew the reservation. So one of the points behind making an objection is to put the reserving state on notice, there's something wrong with your reservation. I want to explain why that might be possible in just a moment. The legal effect of the reservation is to modify the reserving state's obligations with regard to the non-objecting states to the extent of the reservation. I'll give you a simple example in a minute. The international system, you may gather, is based upon voluntarism. States are not dragged kicking and screaming to the negotiating table. They choose to go of free will, to make the promises or not make the promises. So the system is a voluntary system. It's a system also based upon reciprocity. Let me just show you an example. Because reservations operate reciprocally, it means quite simply that each state benefits from the reservations of the other. I'll give you an easy example with the diplomatic bag. One of the things you probably do know, the non-lawyers, about international law is that a diplomatic bag is inviolable. You can never open it for any reason. So the host state can't open it. And the bag is meant only to contain documents and articles intended for official use. But some Arab states, Kuwait, Libya, Saudi Arabia, and the Yemen Arab Republic, made reservations to the effect that they reserved the right to inspect a bag if they thought it contained items that were not authorized by the treaty. For example, drugs, or in the case of some of them, perhaps alcohol. Under these circumstances, other states can exert a right to inspect the bags of Libya and Kuwait and Saudi Arabia and Yemen. Most of you might be too young to remember, but in 1982, in the Libyan embassy in London, rifle shots were fired at a demonstrating at civil rights activists on the street below, killing a young woman police officer, Yvonne Fletcher. It was outrageous that from the embassy should be fired rifle shots, killing people. It, of course, created quite a diplomatic storm, and when ultimately Britain negotiated with Libya that the diplomats could leave the embassy, and the British hoped to figure out what happened afterwards, a few men were seen carrying really, really heavy athletic bags. It was thought they had rifles inside, at the very least of it. But Britain chose not to inspect the bags, and the point was then made, but they had a right to inspect the bags because Libya inspects bags under similar circumstances. And the British took the point of view that we still have diplomats in Libya who would be hostage to what's going on. So while we had the right to inspect the bags, Libya gave us the right by the reservation, we chose not to do it. I now want to get to the convention. What we've just seen, though I haven't said it in words yet, is that when you look at a treaty, you actually cannot tell, looking at the treaty, what promises a state has made. Because you've got to know, did the state make any reservations? The treaty alone will not tell you. You need to look at such reservations as may have been made. So looking at the Disability Convention for a moment, I've given you here the reservations and the objections made by states. El Salvador made a reservation objected to by Austria, the Czech Republic, Netherlands, Portugal, Slovakia, and Sweden. Iran made a reservation objected to by Austria, Belgium, the Czech Republic, Latvia, Mexico, and Portugal. Malaysia made a reservation objected to by Austria, Belgium, Germany, Hungary, Portugal, Slovakia, and Sweden. And then finally, Thailand made a reservation objected to by the Czech Republic, Portugal, Spain, and Sweden. Well, I have to say that I found this curious. And I want you to tell me something that you notice about those states making objections. I don't know whether I should say, yes, I will, I'll tell you, because Jared and I have a fondness for certain things like, for example, Star Trek and Columbo. And I love Columbo because he looks very stupid. He's wearing a raincoat in Los Angeles all the time. And he looks really kind of dumb. And just when the bad guy thinks, I have fooled him, he's such a jerk, Columbo is about to walk out the door, and then he says, wait a minute. Yeah. And you realize he's got him. Well, you are now Columbo this afternoon. I want you to tell me something about what you see. Are you ready? Here we go. What do you see about this? Columbo. Who said that? Are you a lawyer by any chance? No. Oh, good for you. Were you the one who said European? Okay. Let me show you the next list. What do you think? Okay, I'll go back. Yeah. Well, you know what I think Jared and I are better Columbos than you are. I'd have to say, in all candidness, here's what I noticed. We'll do it again. EU. EU plus Mexico. EU. EU. How do you like that? Except for Mexico, every single objecting state was not only a Western European state, it was a member of the European Union. Well, actually, there was a cooperative process to discuss reservations, making it easy for states. But I want to show you something else, because I found that really curious. Is it that, say, the Swedes and the Dutch and the Germans are really, really, really keen on the letter of the law? How is it that no developing countries are making objections? Don't they care? Well, there is a clue here. These are the international lawyers in the Foreign Ministry. The Department of Foreign Affairs asked me 15 years ago now to do an analysis of the provision of legal advice. So I had to go to many countries to get insight. And at that time, the Americans had 128 lawyers in the State Department. The next largest was China. China had 58. The UK had 28. The Netherlands had 22. Sweden had 18. India had 10. As I observed, one for every 100 million people. Guatemala had 4. Costa Rica had 4. I'm embarrassed to say at that time we had 4. But I noticed something about that. I said to myself, you know what? If I had 128 lawyers, I'll bet I could figure out lots of stuff. Whereas if I had only 4, or maybe in the case of the Indians, 10, people are probably put to the pin of their collars to get anything done. It must be extraordinarily difficult. Leaving aside the issue of training, many of the lawyers at that time in developing countries were not trained in international law. The ones here were. Or in other words, getting back to what we just saw. In the industrialized world, they have, let's say, ample legal staff in the foreign ministries. In developing countries, stereotypically, they absolutely do not. It must be very difficult to get anything done for those people because they're short-staffed and there's also an issue of qualification. But anyway, the gentleman over here got it right. He noticed right away they were only European states. That is correct. The last thing to say about reservations is this. It's a kind of curiosity. If you were to look at the literature on international law for the last half of a century, when you come to the law of treaties, a very, very high proportion of all the research and scholarship is actually about reservations. But what you've just seen is that reservations don't seem to be too much of a problem. So that altogether there are around 10 or 11 states that have reserved on the Disability Convention, but there are really only 4, that have reservations that are problematical, despite the tremendous literature on this. I now want to get to probably the essence of what Jared was asking me to talk about, which is the interpretation of treaties, or in other words, what exactly is the promise that has been made? What have we promised? Or to put it in a different way, how shall we interpret our promise? What does the promise mean? In one of the best books on the law of treaties ever written, the writer observes, when he gets to that chapter, there is no part of the law of treaties which the writer approaches with greater trepidation than the question of interpretation, for reasons perhaps we'll see in just a second. First of all, words contain a degree of ambiguity. I think Jared was saying that this morning. Someone was saying that this morning. Oh, I think Jared was saying that this morning. Words do contain a degree of ambiguity. Even if I say yes, it's ambiguous. Did I say yes? Or did I say yes? Did I say yes? Well, even that's a little bit ambiguous, isn't it? And we know what yes means, don't we? Well, words contain a degree of ambiguity. I'll give you a few examples. One series of words that has occasioned hundreds of debates in the Security Council is this: all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. So, for example, the Americans attacking Pakistan with drones at the moment are saying that Afghanistan has a right of self-defense and the drones are perfectly lawful. Pakistan is outraged, thinking it's a violation of her territorial integrity and political independence. Well, for 50 years, we haven't really a clear understanding of whether those acts are lawful or unlawful. Well, to take a few more examples, the right to life, for instance. Well, what does the promise guaranteeing the right to life mean? The important civil and political covenant says that every human being has the right to life. It should be protected by law. But does this mean that abortion is prohibited or that it's okay? In some Latin countries, abortion is illegal under any circumstances. In China, it's a population control policy. Well, which interpretation is correct? When I was teaching in Beijing, I had the privilege of teaching in China for a few years at the very best law school. And when I was teaching the right to life, I had to explain to students that a right has a core meaning that we will agree on, but a periphery where there's a fair amount of disagreement still. And turning to the right to life, I explained to them that abortion in Ireland was absolutely impossible. It was illegal. And they looked at me quizzingly. Why? Why? And I said, well, God doesn't like it. And they said, God? I said, you know, God. They said, God? Well, in China, it's a population control thing. You get pregnant, you don't like it, you have an abortion. Big deal, they think. And I found myself wondering, well, the treaty says we have to protect the right to life. What does this say about abortion? To take a second example, well, I have a few of them there. The freedom of expression. It's interesting. I've often thought that on this issue, freedom of expression, if you stood outside our supermarkets here, like Tesco's or Dunnes Stores, for those of you who are familiar with Ireland, and you asked people over the years, what do you think about Soviet Russia? Or what do you think about China? One of the things they'd probably say, unless they said, oh, big population, is, no freedom of expression. And I was always a little bit bemused by this, because in the bosom of my own family, when it comes to sexually explicit expression, I tend to be a freakish liberal. I think it's okay in private, behind closed doors. My wife is absolutely not a freakish liberal. So we have this disagreement about whether sexually explicit material is okay or not. And that's within the bosom of the family, never mind crossing cultures from Ireland to Sweden to the Netherlands to China or wherever. Or in other words, words have an ambiguity. Rights, indeed, have an ambiguity, like, for example, the right to privacy or the right to a fair trial. In case you think this is foolish, and some of you may well, I am reminded that even in the bosom of the family, there's often disagreement about what a rule means. For example, the rule, be considerate to your brothers and sisters, or be helpful. Ooh, that's a hard one. Be helpful. Or be kind. Well, you know, that's pretty ambiguous. Do I look nice in this dress? No, you look ridiculous. Then she starts to cry. And then my son says, well, she asked. And I was kind to tell her she looked silly in that dress. That is kind. Well, all I mean to say is that words have an ambiguity, and that's within the bosom of the family. If you're talking about a treaty ratified by over 150 states from a variety of cultures, religious backgrounds, political backgrounds, economic backgrounds, it's quite remarkable. When I used to spend time at the UN sitting next to the Iranians, who refused to speak, they did, I used to think to myself, it's amazing that the UN can agree on what time to break for coffee. Yeah, such was the differences. Well, next I want to turn to the ambiguity of international agreements. The problem of ambiguity may be especially true of international agreements for two very important and different reasons. The first one is sort of fascinating. That is, sometimes a word or phrase is chosen internationally to conceal disagreement rather than to reveal agreement. They intend to conceal it, so that it's a matter of, I've been dealing with international affairs almost half a century, I suppose. And it's a matter of fascination to me that when two prime ministers, separate, whether France and Germany or the Americans and the president and the Russians and so on, each one goes back and says to his people, we won! And then I discover with amazement, the Russian prime minister or president goes back and says, we won! Well, they both can't be right, can they? Very often, words are chosen to conceal disagreement, which is not usually so true domestically. Secondly, international treaties are drafted in a multiplicity of languages. The UN now uses 6. And all of them are regarded as the authentic version of the treaty. Very commonly, there are differences in meaning between one type of phrase in one language and a phrase in another language. So it adds to our complication. So that when we're doing the moot this week, I think we're only using English. We're not using Russian, right? How about Chinese? Arabic? Oh, you see, we're only using English. That mightn't tell the full story. Now, as to theories of interpretation, there have been 3 main schools of thought. What is called the textual or ordinary meaning school, the second one, the intentions of the party school, and the third, the object and purpose school. I just want to say something brief about each one of them. In the first, the textual or ordinary meaning school, this argues that treaties should be interpreted in accordance with the actual text of the treaty. It's essential to emphasize the actual words the negotiators chose to use. These words presumably reveal what the parties intended to promise, because it's about what promise did we make, remember? But I have to say, oops, words are often ambiguous. Further, that an issue of interpretation even arises suggests there's an ambiguity in the words. So I'm not so sure this takes us very far. Isn't it more appropriate to examine what the parties really had in mind? So we get to the intention of the party school. This school argues that the prime objective of treaty interpretation is to give effect to the real intentions of the parties, even if they didn't use the right word or the right words. This can be done by examining all the evidence, for example, the negotiating documents, which led to the conclusion of the treaty. We were talking only a little while ago about the background to the Disability Convention from, was it 2002? But I say, oops, so I have the Great Wall of China. I don't know whether you've seen the Great Wall, but wherever you look, it appears to be there over every mountaintop. Well, if you use this school, it may be hard to figure out what the parties really had in mind. That is to say, you have to go over hill and dale sometimes to find their real intention. Thirdly, the object and purpose school. This approach is broader than the other two. In this approach, jurists argue that what's really necessary in interpreting a particular treaty provision isn't so much the words that were used, and not so much the negotiating history, but rather what the parties hoped to achieve. What was their real aim? In this regard, jurists argue, it's necessary to look more broadly at the goal of the parties. What did they really want to achieve? Forget that they used words badly. Forget the negotiating documents, they only confuse us. What did they really hope to achieve? I then say, oops. The difficulty with this approach is that it may be hard, if not indeed impossible, to determine what the object and purpose of a treaty is. If you take the recent important Law of the Sea Convention, it has 320 articles and about 9 annexes. I personally think it's impossible to discover the object and purpose of that treaty. I rather think it's impossible to discover the object and purpose of the Disability Convention. I think it's really hard to figure that out. The Vienna Convention resolves this debate by adopting as the rules of treaty interpretation, oh my God, all 3 approaches. Well, that doesn't help a lot, does it? It probably doesn't. Now, I want to say more about that in just a moment. But what they really did was they tried to embrace each of those 3 approaches. So that in Article 31.1, a treaty shall be interpreted in good faith, we've heard that before, in accordance with the ordinary meaning. To be given to the terms of the treaty in their context and in the light of its object and purpose. Ah, well, I'm familiar with that. But then Article 32 says, recourse may be had to the supplementary means of interpretation, including the preparatory work. Or in other words, they're actually embracing all 3 of those schools of interpretation. At the risk of depressing you, because I don't mean to do that, when we look at state practice about this in the last couple of decades, state practice is actually inconsistent. So that I'm not terribly guided by what states have been doing the last 2 decades, because what they've been doing has been inconsistent. Now, what that means, I get back to the good faith rule in just a moment. What that means is one has to do this exercise in good faith, but there's a certain amount of leeway to interpret the promise that's being made. Well, by way of concluding obligations, and I'm reminded of my cartoon. I hope I haven't confirmed your worst fear of lawyers, or worst suspicion of lawyers, I suppose I mean. Participants should not be led astray, but by what may sometimes seem the abstruse and arcane rules concerning the law of treaties on reservations and interpretation. Because I begin first and foremost, it reminds me of what someone was saying this morning, I think. I begin first and foremost with the view that a treaty is to be performed in good faith. That there isn't an easy exit for slyness, but that the treaty has to be performed in good faith. I personally don't doubt that the more than 150 parties to the Disability Convention intend to implement the Convention's promises in good faith over the course of time in some instances. Reservations to the Convention, which can be problematical, you saw are actually very few. At least difficult ones are very few. And the objectors to the reservations were very few too. Only a couple of Western European states. On the matter of interpretation, the Vienna Convention has attempted to set out, so we think, the essential elements. And I'll conclude with this comment by Sir Ian Sinclair. He was one of the legal advisors to the Foreign and Commonwealth Office and a wonderful lawyer. In his book on the law of treaties, he says, the Convention rules on interpretation have their value by placing emphasis on the key elements of interpretation and on the relationship between those elements. The Convention rules establish a set of guidelines which are not only firmly grounded in antecedent practice and international case law, but which serve to indicate to the would-be interpreter the relative weight which he should attribute to each of those elements. Well, that is true, I think, in the abstract. There is room for disagreement in the way that I've explained to you, which on the one hand can make for mischief. On the other hand, if one accepts the good faith of states in the first instance, whether ratifying a torture convention or a climate change convention, or in our case, a disability convention, if we accept good faith, I think the problem is at least half resolved. And I don't have a drum roll to conclude because this presentation I've been asked to give has been, of its very nature, somewhat miscellaneous. But thank you for your attention, and if there's time, Jared, I'll take one or two questions if there are any.